So what MERS has done basically, according to the accusations that the attorneys are making in court, is they've obfuscated the chain of title. When it goes into the MERS system, you have no idea who owns the note. It gets sold and resold and resold, and if you look at your mortgage or deed of trust, in the long form, which is like a form 3043, 3044, 3048, they're Fannie Freddie uniform instruments with MERS. And if you look at paragraph 19 or 20, clause 19 or 20, under sale of note, change of servicer, this is what gives them the license to take your note, split it off from the deed, and run with it. And so they're out there on Wall Street selling this note. It's been paid over and over and over again. And because it's tracked on the MERS electronic database and never recorded in the land records, you have no idea, not only who doesn't, you have no idea who owns the note, but also the assignments are never recorded.
There's no chain of custody going.
There you go. Yeah. And see, when you're looking at the chain of custody of the note versus the chain of title, they're in two totally opposite directions. You have no idea. And this is why we do chain of title assessments, because that's one half of the equation.
Right.
And so we're training people to do what I do. I have attorneys calling me from all over the country, Rob, and they're asking me, look, would you look at this person's title from the warranty deed forward and tell me what's wrong with it? And I've actually, attorneys have literally just missed these things. This is what I train people to do, is to, you know, put on the eagle eye and spot the problems.
And now, going to your seminar or getting the book, is this for people who are thinking about buying property or have already bought property, or, you know, is it, if they're already getting foreclosed on, is it too late for them to start learning these things?
Actually, I have a lot of people coming to this upcoming CODA seminar in Chicago, the workshop, and a lot of them are being foreclosed on. I had a woman in Las Vegas today, and she's coming, and she told me, I've lost millions of dollars in real estate. I own a lot of rental properties. And she says, I want to learn what's going on here because I have a sneaking suspicion that I've got, you know, a pretty good case on a lot of this stuff. And I said, well, you might. I said, the saving grace about Nevada is they just passed Assembly Bill 284. Lenders can't just come into court willy-nilly and file all these documents. They have to attest to the validity of the document, and if they don't, it's criminal.
Right.
And they can actually get jail time and get disbarred. So this was a huge thing in Nevada, which, by the way, when you looked at that 2012 foreclosure map that you were showing on there, you see what we call the sand states.
Right.
This is where the biggest hit was taken. If you notice, in 2008, which is what you're looking at right now, you'll notice that Southern California and Nevada, especially up in Vegas, Reno, all up, you know, and when you go through the, like Florida, Florida, Arizona, Nevada, and California are what we call the sand states.
Right.
You'll notice how much pink is in there and how it was hit in 2008. Well, as the jobs started to diminish, if you go to the 2012 map, look at this. Now you look at the Rust Belt up there in Michigan and Iowa and all those places in there, you notice how all of a sudden there's big clusters of foreclosures going on. We're looking at another 4 million foreclosures in 2012, and it just keeps growing and growing and growing.
It's an epidemic, and a lot of this is people were duped into these, they were given, and now we've learned that the interest rate that everything's based off of is false as well with the LIBOR scandal.
Exactly.
So it's just scandal after scandal after scandal. Let's get into robo-signing, because that's another part of this where you have people signing these titles who aren't licensed to sign them, but they're just signing them for somebody because there's a glut of these things that need to be signed. Is that, am I getting that right? Or
basically, the term robo-signing was coined by, you know, there was a handful of attorneys that started doing depositions of these people that were assigning documents. And when they looked at the assignments, they basically said, well, you know, what's wrong with this picture? Because here we have an assignment from this person, Linda Green, and she's signing this document as vice president for Wells Fargo.
Right.
But then we turn around and we have the same address and same zip code and same people preparing the documents, and here's Linda Green signing again, only this time she's signing as vice president of Chase.
Yeah.
And so it's like, well, wait a minute, the two Linda Green signatures are markedly different.
Yeah.
And so this is another term, what we call surrogate signing. This is where they have, and they actually did admit to this, they have signing rooms in places like the now defunct DocX or Docs, D-O-C-X. And if you happen to be going through your assignments in the land records, ladies and gentlemen, and you happen to see the name Ronald Mayharg on the top of your paper in the upper left-hand corner, and you look down and you see DocX or DOCX, all of a sudden, red flags should go up, because the people that are doing this, these people were document manufacturers, and what we're finding out that they did, it appears that they have one room full of people. All they did was sign their names to documents, 350 of them an hour.
God.
and they're paid $10 an hour to sign as vice president of some bank, and we don't even know, when you ask them in deposition, where is the authority that you have to sign these things? Do you have a power of attorney or some signing authority that's been giving you, power to sign your name as vice president of these? And a lot of them are signing them as vice president or assistant secretary for MERS. And what they're doing is they're conveying the note. And a lot of these cases are saying that MERS doesn't have the authority to convey the note because MERS doesn't have an interest in the note. You can only grant what you have an interest in. And according to the contracts you signed at closing, which was your deed of trust or mortgage, you only gave MERS the power to be the beneficiary on paper. And what that does is it creates a static condition in the land records, according to the way that we were looking at their business model. And it appears that this static condition basically will suffice for all the transactions that are conducted outside the recorded system that we know it.
Right.
This system started back in like 1600s, 1638 in Plymouth, in the Massachusetts Bay Colony. I mean, this thing is as old as this country. And, we've relied on this, and the judges are even starting to turn an eye to this stuff and say, there's something really weird going on here, and if you don't give me the entire chain of title, I don't know exactly how you got it, Mr. Lender. And so this is where we're having, big issues in court. There's just, the robo-signing thing is literally touched off a firestorm of depositions. And we have robo-signers here in Austin, Texas, that are being called on the carpet. One signs as a signer, as vice president of One West Bank, but then they were, of course, taken over by IndyMac Bank, and the FDIC was the receiver. And before, we have the same person signing as a vice president of IndyMac Bank. And it's like, and then she admitted in deposition, she never even read the document. She never even knew what she was signing. And then we asked, the attorney asked her, and where is the notary that supposedly witnessed this document? Well, the notary's in another part of the building. So when we go into depositions, when we consult attorneys, we ask them to get a copy of the floor plan of the building that the person signing these documents sits in, because then we can say, okay, now where does the notary sit in relation to you? Because Texas law clearly says the notary must be present when you sign the document, and you must sign their logbook. They are required to keep a journal. So when we go into deposition, we say, okay, where's your journal? The attorney would literally say, I need to see the journal. Show me where in your journal it says that you witnessed this.
And defense says there's no journal. There's nothing there.
And they say, well, we're not required to keep a journal. Well, excuse me, Texas law says you are.
I just went and got a document notarized at a bank, and they have a journal. And they put a stamp on it.
And they made you sign it, didn't they?
Yeah. And that's the way it goes. It's a proper paperwork procedure, as they say.
Exactly.
And so let's go into what this means for, I guess, the housing industry in the future. What is going to happen when the dust settles on all this? Are people going to, if you bought a house, say, can 10 years later somebody come back and say, hey, that wasn't done right, that's still my house? Is that going to be happening in the future?
It is happening.
Oh my God.
And not only is it happening in that regard, but it's also because of the MERS system, we are seeing a lot of cases where homeowners who thought they paid off their house are being subjected to double liability.
Right.
In other words, a lender is coming out of the securitization system and saying, hey, I had an interest in this, and as far as we know, we still have an interest in this property. And they're saying, but we paid it off 6 years ago. Well, we don't care. We're the servicer for this investor, and this investor says he owns it, so we're foreclosing. This has literally touched off a firestorm of lawsuits across the country. People buy short sales. 2 months later, Chase Bank comes in, forecloses on this guy, cleans out his entire house, winterizes his toilets. He has to break in the basement window to discover all his heirlooms are gone. Everything's gone. He has a lawsuit against Chase. They break into some woman's house in Pittsburgh, Pennsylvania while she's at work. They steal her pet parrot. Go figure. She has to drive 2.5 hours to get her parrot back, but all her furniture is cleaned out completely. They've winterized the toilets. She is not in default on her mortgage. We have people that the banks have foreclosed on when the banks don't even own the loan.
Right.
It's that crazy because the left hand doesn't know what the right hand is doing, especially when you're dealing with a servicer and a trust entity and a bank. And everybody's getting different information, and it's coming through what we call a third-party document mill. And there are identified third parties that we talk about in the book, like lender processing services, like CoreLogic. They have a document solutions in Chapin, South Carolina on Boundary Street. We watch their stuff, because we're seeing documents come out of there that are generated by people, and they're using addresses we know are phony. And so we actually have talked to the leasing agents at these addresses, and they say, no, MERS has never been here. And we have documentation. We know who to go depose.
Right.
The paralegals that I work with, because we formed DK Consultants LLC for a reason, and that was to actually assist counties in land record audits. And starting in October, we're actually auditing a county in Central Texas that literally is looking at the behavior of one specific attorney. Because they have him organized, all his signatures are organized by notary, because all the notaries on this document, this stack of documents, look the same as far as the attorney's signature. But when you look at what this notary's doing, all the attorney signatures are different from this one. And when you go to the next stack, and there's 6 different notaries there, and they've got the same attorney's signature all the way down the line, and all the notary signatures compare with each notary that's signing these things, like the notary is surrogate signing his name and then stamping it. So you got to wonder whether the attorney is present at the time these things are being signed. I think a grand jury would like to know that.
Well, and you got to wonder how people could just do this openly and blatantly over and over again and not question it and not even whistleblow on it. How did this stuff start coming out? It wasn't people whistleblowing.
It was, as a matter of fact. There were a lot of whistleblowers, like Lynn Zamoniak, who's a fraud investigation attorney in the middle of Florida, near Jacksonville. And she actually blew the whistle and was on CBS 60 Minutes.
Oh, she was in the
Scott
60
Pelley.
Minutes piece.
And I was there with her when that aired. We had a big party, and there were a lot of homeowners there that were being foreclosed on, that are right in the middle of foreclosure issues, and had hired attorneys. And we watched this, and it was hard to hear because everybody was screaming at the TV because they knew what was going on. They've had this happen in their own cases, and you just about cry looking at the sadness and the scope of this, and how deep it goes, and how much of an issue there is with the chain of title versus chain of custody of the note. And so, you know, the reason that I started doing these CLEs for attorneys in the seminars is to get people up to speed, because frankly, folks, I can't do this all by myself. So I'm willing to share the wealth and teach people how to make a good living.
Right.
And that's why we started the CODA workshops.
Excellent. You know, you mentioned that 60 Minutes thing. I found an article from recently. A Jupiter Farms family says their robo-signing victim's house to be auctioned, and they watched that 60 Minutes piece. They went around, did their own homework, found out they were part of this robo-signing thing, but it didn't matter. They still got foreclosed on. They had to, their house got auctioned. So, like, if somebody's in this situation, what can they do if they figure out, hey, I'm being robo-signed on? Is it? I mean, how wet do you have to get in order to get your house back?
Well, you seriously, and this is one of the things, you know, we talk about in the book under Section 3. It's called strategic default. And in this particular section, I put it in here because I'm going to be honest with you, Rob. I walked away from a mortgage in 2003. I walked away from the house. I packed it up. I called the bank. I says, here, it's yours. Take it. I can't sell it. I'm upside down.
Right.
They have new build jobs going on in the same subdivision that I'm in, and I can't sell my house because they can buy a brand new home cheaper than what I can sell my house for.
Sure.
So you know what? I've had it. Nuts to this. And at that time, you know, my mortgage payments were only $900 a month.
Wow.
Total between the first and the second. And they ended up selling the house and getting all their money out of it. But the thing is that, you know, when you're looking at issues like this, a lot of people are doing this. They're looking at this book, and they're using it as a tool, and they call me and they go, well, should I stop paying my mortgage? And I'm like, look, I don't even know of an attorney that would answer that question without getting himself